Welcome to Talk Lytical TV. I'm your host, Lytical J, and I'm back with another logical perspective. All right, let's jump into this document I have up on the screen. As you can see at the top of the screen, it was e-filed today, 5/26/2022, and this was filed by Melly's defense team. Let's go ahead and jump right in. So, the defendant, Jamel Demons, by and through the underdesigned attorney and pursuant to, y'all see it, hereby files a demand for speedy trial indicating that he is available for trial, has diligently investigated his case, and that he will be prepared and ready for trial within 5 days from the date of this demand. Under Florida speedy trial status or state statute, anyone accused of a felony is entitled to be tried within 175 days of having been taken into custody. B. Speedy trial upon demand, except as otherwise provided by the rule and subject to the limitation imposed under subdivision, and every person charged with a crime by indictment or information shall have the right to demand a trial within 60 days by filing with the court a separate pleading entitled Demand for Speedy Trial and serving a copy on the prosecuting authority. So 1. No later than 5 days from the filing of a demand for speedy trial, the court shall hold a calendar call with notice to all parties for the express purposes of announcing in open court receipt of the demand and of setting the case for trial. 2. At the calendar call, the court shall set the case for trial to commence at a date no less than 5 days nor more than 45 days from the date of the calendar call. Number 3, the failure of the court to hold a calendar call on a demand that has been properly filed and served shall not interrupt the running of any time periods under the subdivision. And lastly, 4, if the defendant has not been brought to trial within 50 days of the filing of the demand, the defendant shall have the right to the appropriate remedy as set forth in subdivision P. All right, so key points for me. Let's get lytical. Let me just kind of break it down to you in a different way. All right, so of course, his attorneys are demanding that he gets a speedy trial. By June 3rd or so, the judge in this case has to set a calendar call date, right? And the reason why I say by June 3rd is because, number 1, it says no later than 5 days from the filing of a demand for speedy trial. So around June 3rd or so, the judge in this case has to set a calendar call date. At said calendar call date, the judge will need to set the case date for trial by June 8th or by deadline date of someplace around July 25th, 2022 to meet the requirements per court law, which is like the 45-day period, right? All right, so Melly's lawyers is clearly saying, like, hey, we as a defense team, we have reviewed all the motions, discoveries, aka evidence, spoke with all the witnesses, etc., in this case, and we're ready to go. So at that point, it can go a couple of ways. 1, prosecution says, let's go, we ready too. 2, prosecution says, for whatever reason, hey, we aren't ready and need more time. At that time, the judge in the case then would say to prosecution, prove why you need an extension, right? Now, if prosecution cannot get the judge to agree then that forces the prosecution to either proceed on with said trial date, ready or not, or 5, and of course, if they can convince the judge to give more time, then that's what will happen. Now, I did glimpse that trial date is supposed to be starting around July 6, 2022. So, I mean, I guess that would fall into the guidelines. But again, being that they went ahead and filed this demand, they're pretty much pushing the state to say, we're ready too. At the calendar call that the judge is going to get ready to come up with the date to see. And again, if they force prosecution into that calendar call and for whatever reason at that time they're not ready, then it's either they're going to go into trial not being ready. Now, not being ready doesn't mean, well, they don't have their case together, but not being ready could mean they're still trying to get with a couple of witnesses that they can't contact. They're still trying to rectify what is not going to be presented to juries or not. Like, those are called pre-trial things. So if prosecution still has things they need to work out and they're not ready, then this will definitely prolong. But that will put the heat on them to either start trial without being ready, or get more time. That's pretty much it, and that's all up to the judge. So, just jump down in my comments and let me know what y'all think about this update. I think it's smart. I mean, this is what lawyers do. Again, they come up with all types of motions to see where they could get in, where they could fit in. And I feel like this is very smart. I feel like the state is ready, but let's see. We all sitting, waiting, ready to see what's going to happen. So comment down below and let me know what you think. That concluded the end of this video. Thanks for watching. Don't forget to subscribe, comment, and like. Bye.